Hello and a warm welcome to each one of you. It's my pleasure to welcome you to today's webinar, Understanding Your Role as a Licensed Professional. I'm Felix, the webinar coordinator from the Continuing Education Department at the OAA, and I'm happy to facilitate today's session. We will begin today's webinar by acknowledging the land on which we are meeting and calling in from today. For millennia, the place we call Ontario has been inhabited by Indigenous peoples and nations who have been stewards of the land and are deeply connected to its rich cultural and natural landscape. We would like to invite you in a moment of reflection to acknowledge our shared responsibility to address past and present injustices and provide space for Indigenous knowledge and worldviews to shape the architectural landscape of Turtle Island. Before we commence, I would like to share some important information to ensure an effective and professional webinar experience. Please be informed that the session is being recorded for quality and educational purposes. In order to maintain a stable internet connection, we have muted all participant microphones and disabled video feeds. We highly encourage engagement through our Q&A window. Feel free to submit any questions you may have for our speakers. These will be addressed in the designated question and answer period at the end of the presentation. Kindly note, the chat function will be deactivated following this introduction. For those seeking continuing education learning hours, please note that attendance is crucial. A minimum of 80% attendance is required for these hours to be credited to your transcript. Please allow a few weeks for the processing and reporting of these hours. And lastly, please note that the presenters do not provide insurance, legal, or practice advice, and the OAA does not bear responsibility for errors or omissions in discussions during the webinar. For accessibility, we provide automated closed captioning service available in multiple languages to accommodate the needs of our diverse audience. Now, I'm excited to introduce our speakers for today's session. Please welcome Melissa O'Day and Claire Hepburn. Thanks for your attention, and let's now proceed with the session, and I'm passing it over to our speakers, Melissa and Claire.
Thank you, Felix. Good morning, everyone. So Claire and I will be presenting today. So Claire is the Deputy Registrar at the OAA. She is a licensed lawyer. She oversees the complaints process, act enforcement activities, and continuing education service area. Before joining the OAA, Claire worked as a lawyer and manager at the Law Society of Ontario, the regulating body of lawyers. I'm Melissa O'Day, Manager of Practice Advisory Services at the OAA, and I'm also a licensed architect. I work alongside practice advisors to coordinate the delivery of a broad range of practice services that support members and architectural practices, such as the OAA hotline, oversight of the OAA 2021 contract suite and guides, the administration of the CSA Standard Access Program, etc. So I'll pass it on to Claire. Go ahead.
Thanks, Melissa. I am going to just provide a brief overview, and then we're going to actually just jump into a poll. So have your keyboard ready. So today we're going to explore the benefits and responsibilities that come with being a licensed professional. We're going to provide a brief roadmap for what professional self-regulation looks like, what it means, what the role of the OAA is in that whole landscape. Then we're going to look more at the privileges of membership. What do you do as a member of the OAA, and how is it that members of a regulated profession have responsibilities which others do not? Then we're going to look more in detail about at your responsibilities as a member. What are your professional obligations? And more importantly, where you can find more information about those obligations. And then finally, we're really going to look at the whole so what of everything. How does this affect your everyday practice? And we're going to look at two scenarios that we've come up with that are pretty common pitfalls for architects. We're going to discuss them and hopefully leave you with some very valuable takeaways. Melissa?
Yes, so let's start with poll number 1. What are the purposes of self-regulation? Please select all that you think apply. You'll have about 10 seconds by the time I finish, after I finished reading the options. A, to set standards for entry into the profession. B, to advocate for fair rules for architects. C, to encourage the public to use architects over other design professionals. D, to promote a public appreciation of architecture. And again, this is a multiple choice.
Thank you very much, Melissa. Let's give our members a little bit more time to
Sounds good.
answer the first poll question.
And by the way, you're going to get, this is meant to be like very participatory, so you will get multiple polls. So again, encourage you to just jump in, and all the information is confidential as well.
Great. So it looks like 80% of the participants have now entered their answers. So Melissa, here are the results to the first poll question.
Okay, so just looking at, gonna switch to my next slide. All right. So 89% of you, so we have about 235 that answered. So the majority answered A, to set standards for entry into the profession. 63% said to advocate for fairer rules for architects. 44% answered to encourage the public to use architects over other design professional. And the last one was 49% to promote a public appreciation of architecture.
Interesting.
So I just wanted to thank everyone for participating. As you can see on this slide, A and D are correct. So Claire will be getting into more of that background in the upcoming slides.
Thanks, Melissa. That's an interesting bit of information for us when we look at this to see where everybody's at. And hopefully we'll come away with a clearer sense of why some of those things don't apply. So specifically, I'm going to give a really high-level overview about what self-regulation is. And essentially what it is a process by which the government permits a profession to formally regulate its own members. And that agreement comes on the condition that the profession is doing so in a manner that serves and protects the public interest. That is the central purpose of self-regulation, and it's the lens through which all activities occur. So that's why when we look at other self-regulated professions, we see it where the services that those professions offer come with an inherent level of public risk that would impact the public welfare. Obviously, in the case of architecture, it affects the space around us, and of course, the construction of safe and long-lasting buildings. So this next slide really provides a helpful overview and situating the profession of architecture. Architecture is among 13 other non-health professions. There are 26 other health professions that are regulated under a separate act, and there are 23 compulsory trades that are self-regulated in Ontario. The OAA itself is quite an old profession. It was established in 1889. Currently, we have about 4,900 licensed members and approximately 1,900 interns. And really, that's a fairly small profession when we compare it to something like the College of Teachers in Ontario, which have well over 100,000 members, as do the College of Nurses. And even the lawyers, the Law Society of Ontario has well over 60,000 members now. So the next slide is really a helpful illustration. It's helpful to visualize the path of self-regulation as a roadmap. So I'm going to kind of walk you through the visuals here to hopefully give you a clearer picture of what it means to be part of a self-regulated profession. So as we've discussed, that agreement between the government and the profession comes in the form of legislation or an act or a statute. All those words are sort of used synonymously, but essentially what that means for the OAA is the Architects Act. That is the governing legislation. The act is the primary set of laws. It's a hierarchy. So those are the guiding laws that set the requirements for practice, defining what the scope of practice is, the governance structure of the profession, among other things like standards of practice. The Act will also establish, or also does establish, the passing of regulations and bylaws on very specific enumerated topics. So those bylaws and regulations go into more detail about what that Act sets out. Stop number 2 on this roadmap is the purpose of the Act. That's the primary object, which is embedded in the Act itself. And that is the lens through which all decisions and policies and requirements are administered through, which is, of course, service and protection of the public interest. Then we get to stop 3. That is the OAA. The OAA is delegated through the Act to be the legal authority to administer the requirements set out in the Act. And then step 4, what does that actually look like? It means that the OAA is involved in setting and enforcing standards, establishing academic requirements, regulating and overseeing professional and ethical conduct, and managing and ensuring continuing competence, which you're all participating in today. Then step 5, we see the members, the licensed members, the audience today. And what are those expectations? Those expectations are to uphold those standards, to maintain ongoing competence, and of course, to remain responsive to the regulator. And then finally, step 6 is the government oversight. So I want to make it very, very clear that the self-regulation is a privilege, and it's certainly a privilege that can be lost. It is not a right. Now, the government has a vested interest in ensuring that the profession is governing itself without issue, because members within the profession are generally best suited to set those standards and oversee the business of regulating the profession. But if it's seen that the profession is not doing its job and it's acting instead in the interests of its own members, not the public, that privilege can be taken away. So I want to move to this next slide, this next visual, which is a really nice overview of all of the different activities. We're not going to be discussing each one of these specific areas of service that the OAA provides, but I wanted everybody here to get a sense of the breadth of activities that are involved in regulating a profession and all of the work that we do. We are going to be speaking more specifically to Act enforcement, complaints and discipline, a little bit about continuing education requirements. Melissa is going to be talking more about practice advisory services, but I wanted to give this image after going through the roadmap, because I understand that trying to navigate all of the ins and outs of legislation and regulation might seem a little bit overwhelming. And if you're not wading through legislation every day, it can seem inaccessible. So the OAA has so many good resources, so much good information that are in really accessible formats like practice tips, regulatory notices. And we also have a hotline that Melissa is going to be talking more about too. And she's put up some really helpful slides for you to consult when you come up with an issue.
Perfect.
And I'm going to hand it to Melissa. Yeah.
Yeah, perfect. Thanks, Claire. So yeah, I just bombarded everybody with about 10 links, but hopefully, again, these will be also added to the presentation. So again, I really encourage you to get familiar. These are all on the website, member side and public side, which we will touch base a little bit later. So poll question number 2. How familiar are you with the Architects Act and Regulation 27 and/or the OA bylaws? A, I don't consult them. B, I consult them once or twice a year. C, I consult them once or twice a month. D, I consider myself well-versed in their structure and content. So we'll let Felix let us know when about 80% has participated.
Yes, thank you very much, Melissa. Let's wait a couple of seconds more. Perfect. And now Lisa, let's end the poll, and here are the results.
Beautiful. All right, so about 28% of you say that they don't consult them. 50% consult them once or twice a year, 11% once or twice a month, and 7% consider themselves well-versed. So as many, kind of as a note, and what Claire was mentioning, many of the regulatory notices and practice tip offer refer to key sections of our Act and regulation. We often, at the hotline, which is if you call the OAA, you can either email us or actually call us at extension 400. We often get questions related to Section 11 of the Act, which is what is protected scope. Section 49 of the Regulation 27 regarding standard of practice, and so forth. So bear in mind, I think I look at it daily for the job that I do with myself and the other practice advisors, but ultimately it's not a question of knowing it by heart, but understanding how to navigate it is really key, as it lays the foundation of who we are and what we do as part of a self-regulated profession. So I'll leave it to Claire next.
Thanks, Melissa. Yeah, I'm going to be digging in more to the public interest standards and one of the unique qualities of the Act. And one thing I do like to really discuss and share is this underlying intention of self-regulation. I think I mentioned earlier, in society, there are certain professions and occupations where when the work is performed, or rather the work that is performed and the activities in that profession are of such a nature that if they're carried out in a negligent or fraudulent way, it can be very dangerous to the public and certainly contrary to the public interest. So if you think about lawyers who hold millions of dollars in trust account, if they're absconding with that trust money, very bad doctors who perform surgery without necessary skill and competence, very, very risky. Architecture, obviously a poorly designed or poorly built structure is very dangerous. We don't want to see buildings falling down. And at this point in the webinar, I'd like to turn to this quote from the former Chief Justice of the Supreme Court of Canada, Beverly McLachlin, who actually practiced in the area of architecture and engineering law. And what she said specifically about the practice was that a significant characteristic of the architecture profession is that it depends on confidence of two kinds for its effective pursuit. First, the personal confidence of the client in the technical competence of the architect. Second, the confidence of the public at large in the integrity and ethical conduct of the profession as a whole. Architects generally operate as independent practitioners, providing services that are not subject to detailed control by those whom they serve. The subject matter of their services is generally of a complex, technical nature, but which clients are relatively ignorant. For these reasons, the client must place trust and confidence in the competence and skill of the professional architect. This, in turn, imposes a correlative duty and a responsibility upon both the profession and the individual architect to justify the trust of the public and the individual client. The last thing I will say about the profession itself, in addition, obviously, the overarching requirement is public interest, but one of the secondary objects is around education and appreciation of the of architecture. It sets out in the Act that secondary object is to establish and maintain or assist in the establishment and maintenance of classes, schools, exhibitions, or lectures in, and promote the public appreciation of architecture and the allied arts and sciences. And I think this is we don't see this in, I'm not aware of any other profession in Ontario that has a similar secondary object. And I think it really reflects that element of creativity and art that is very special in this profession. So I wanted to highlight that as well for the audience today. So the next slide is, again, another clear indication that the role of the regulator is to regulate and not advocate. I think that the first poll, there was a lot, I can't remember the exact percentage, but it was quite high who felt that the OAA's obligation was to advocate for the profession itself. And I want to be very, very clear, there are bodies who do that function, and it's not a bad thing, absolutely not. But the role of the regulator is to promote the public interest. So when we, and I just mentioned that last clause that deals with appreciation of architecture, very, very clear, it's promotion of architecture, not promotion of architect. So if you leave with nothing else today, please be really clear that the role of a regulator is to ultimately serve the public interest. And again, as I mentioned, there are other bodies like the RAIC. That is the body that would serve the role of advocate for the profession itself, not the OAA. So the next slide is talking about another lens through which the OAA is going to implement its policies and administer the act itself. So right touch regulation, as the slide indicates, it's not a separate act, it's not a separate regulation, it's not even set out specifically. It is a lens through which we make decisions as regulators. And so this illustration really demonstrates how regulators need to balance the regulatory force. So we have certain tools like act enforcement, complaints, discipline. I'm going to talk more about that later. And then we have the risk that we're trying to prevent. So if you want to think about a good example with a criminal investigation, do we want our provincial police putting all of its resources to investigate a jaywalker, or are we more concerned about somebody who's committing murder or horrible crimes like that? So it's that kind of, that's an extreme example, obviously, but it's similar to how we want to think about using a regulator's resources. Very important, especially for a smaller regulator like the OAA, where resources are always going to be a factor, and where we want to strike that balance between proactive responsibility, like educating, licensing requirements, practice requirements, versus those more reactive responsibilities that are like prosecuting somebody for misconduct. Other key ideas around right touch, which I think are just generally good in terms of problem solving, are to identify the problem before the solution. And that means often that we want to qualify and quantify what those risks are instead of just, going to the act and hitting enforce, getting as close to the problem as possible, focusing on the outcome. And that can also look at, checking for unintended consequences. And that's why one of the principles of right touch is to only regulate when necessary. We do see sometimes there's a tendency to want to regulate when we see a problem. A good example is climate emergency. We see all of these issues. We want to find a solution. And sometimes we have to take a step back as the regulator and really be clear about what our role is. And that's, specifically education, ongoing competence, that kind of thing. We can't necessarily fix the whole problem, as frustrating as that is. And then the last 2 points are really just trying to keep things simple, keep regulations simple, and being responsive to change. And then we have another poll.
Yes. All right. So Felix just launched it. So what are some of the privileges of self-regulation? Select all you think that apply. A, exclusive use of a protected title. B, legal advice about how to draft changes to a contract between you and your client. C, ability to practice within a protected scope of practice. And D, exclusive access to regulatory notices and practice tips, sorry. We will give a few more seconds.
Thanks again, Melissa, for poll question number 3, and let's wait a little bit longer. Okay, great. Let's end the poll, Melissa, and share the results.
Perfect. So I'm going to switch to, so in terms of percentages, 74% of you selected exclusive use of protected title, 43 about legal advice for contracts, 80% the ability to practice within a protected scope, and 57% of you selected exclusive access to regulatory notices and practice tips. So again, Claire will be getting into A and C in more detail. For D, as you know, our website has a member side and a public side. So for example, all regulatory notices and practice tips are located in the Practice Knowledge Base portal, which can be accessed actually by both clients, and that is also the general public. As for B, members are encouraged to work with a lawyer when needing to amend or create contracts. Again, I encourage all of you, if that's not already done, to get familiar with standard forms of contracts. Maybe the OAA ones or the RAIC also has some very solid templates. So I think Claire just put a really good link for you for both clients, basically helping you to maybe explain to clients why you should have a standard form of contract, and that's located on the public side of the website.
Okay, so now I'm actually going to be getting into some of the privileges of membership, and it's really interesting. I can't help myself. I look at the answer around providing legal advice, and I think the OAA cannot provide legal advice, and the reason is kind of related to the protected scope that only lawyers can provide legal advice. And so it's important that that you have that in your practice, but it's certainly something that the regulator cannot do. And it's also a conflict of interest for a regulator to provide individual legal advice. We can provide legal information and resources for you to make those decisions, but again, I just wanted to hit that home. So I'm going to be talking about the privileges of self-regulation, and there are certain qualities essential qualities that all regulators, all professional self-regulating professions have. They all have a highly developed and specialized set of skills and knowledge. There is an underlying commitment to duty above self-interest or personal gain. And then third, there's an independence from external interference into the affairs of the profession. And that last point is really one of the core privileges of membership. And the way that privilege is carried out is through the governance structure. So we actually have to look at the Architects Act in terms of how that's set out. In terms of the OAA holds annual elections. We just had an election to elect council, which sets policy direction, makes critical decisions regarding the future of the profession. It's certainly not an obligation to vote, but I certainly encourage everybody to vote because it's a very important role that council have. Our council is made up primarily of members. Currently, there are 15 licensed members, and there are up to 5 members of the public who can be appointed by the government. They're called Lieutenant Governors in Council, or LGIC for short. And in addition to the council, OAA relies on its members to participate in many, many committees, statutory committees, standing committees, task force, working groups, roundtables, to address everything from the handling of complaints and discipline to comprehensive education and sustainability. So again, I would also encourage everybody here to participate in your profession. It's so important. But what does that all mean? It means that as licensed members, we maintain, or you maintain, a great deal of autonomy over how the profession of architecture is regulated in Ontario. And that includes prescribing professional and ethical standards, addressing professional misconduct, and determining who should gain entry into the profession. Now, it certainly does not mean that architects can do whatever they feel like, and it should go without saying at this point in the presentation that everything, all of these activities, all of these committees I discussed, all of the ways that we administer the Act must do so in service of the public interest. And I will say it's very important to note that it is possible, and it has happened, that regulators have lost the privilege of self-regulation. If the regulator is found to put specific interests of the people they regulate instead of the public interest, the government will intervene. And we've seen a number of professions who've had to grapple with greater government oversight, and in some cases, they have lost that privilege altogether. When regulators are failing to protect the public from illegal or unscrupulous practices, there's some good examples. A lot of the examples we see are coming from out west, like in BC. Recently, the realtors lost their ability to self-regulate. We've seen other examples as well. So again, I just say that because it really underlies the privilege that we have to work really hard to uphold. Okay, so the next slide is Melissa.
Perfect. And I put, as you were talking, Claire, I put some information on our OA Council as well as different committees. And I'll do a last pitch. In September, we usually do a call for volunteers. So again, I encourage everybody, if you have a bit of time, to participate. So this slide is a bit of a snapshot of what has been done in terms of enforcing the Act against illegal practice and unauthorized use of the protected title. While confidentiality is maintained about individual instances of Act enforcement, the OA does release the information in the aggregate. The graphic summarizes the OA's enforcement activities for 2023. Of the 287 investigation in 2023, which includes both new matters as well as active ongoing investigations, 234 were resolved by the Office of the Registrar, which means no further action was required due to the OA's enforcement hierarchy matrix, that there was no breach or changes were implemented, and one resulted in a now resolved injunction. As of January 2024, there are 52 that remain ongoing. The OAA relies on its members, the public and other stakeholders, to alert them to possible breaches of the Act. Members also have a professional obligation to report unauthorized practice if they encounter it. Information, including the OA's public register, is also available on the website to the public about OA members. Note that temporary license holders are not listed in the register. Act enforcement is one of the ways the OA ensures that the public is protected. As a regulator, the OA ensures that only properly qualified and registered members and practice in architecture. So I will let Claire take the next poll.
Okay, so I'll read it out loud and give you a little bit of time to answer. So the question is, what are my obligations as a licensed member of the OAA? Please select all that you think will apply. Complete continuing education requirements set by council policy. Report purported misconduct of other OAA members to the registrar. Provide mentorship and supervision to interns and new architects. and vote in all elections to appoint new members of council.
Yeah, thank you very much for poll question number 4. And again, let's give our members a little bit of time to finish giving the answer.
While members do that, some of the stats that were presented in the previous slides are also part of annual reporting, and this information also updated on our website.
Thanks, Melissa. And Claire, let's finish the poll, and here are the results.
Okay, that's good. I thought I might have given it away earlier in the presentation with the final question, but the correct answer, is A and B. Both of those requirements to complete your continuing education requirements, that is a requirement set out in the regulation. And to report purported misconduct to the OAA, that's also set out in the regulation under the standard of practice. Every member of the association or holder must promptly bring to the attention of the registrar any act, omission by another member or holder that may constitute professional misconduct. So as I said, while we would love it if everybody voted, it's not a requirement. And again, likewise with mentorship and supervision, it's a very important part of developing this community of practice, which is so important in professions, but it's not specifically a requirement.
Perfect. Okay.
Okay. So we'll move on to responsibilities now. What are my responsibilities as a licensed member? Members of a profession obviously have a vested interest in the proper function of their association. As I've noted, members gain substantial benefits from self-regulation, including the professional prestige, greater autonomy to set requirements and standards of practice, and the exclusive use of title and protected scope. To protect these benefits and privileges, there must be oversight of its members. The inappropriate acts of one member can have a significant negative effect on the entire membership and can diminish the image of the profession as a whole. It is in the profession's best interest that incompetent and unethical behavior be removed or dealt with. Not only does the profession have a duty to ensure its proper operation in the public interest, but it also must ensure that the public perceives this to be the case. If the profession is unable to properly self-govern, as I said earlier, that status can be removed. So again, reminder, practice self-regulation is a privilege, not a right. And the practitioners must always practice the profession in accordance with the regulator's rules and standards of practice. So now we're going to look at some of the basic requirements that are outlined in the Architects Act and the bylaws as well. So I'm sure everybody knows that there are membership fees that are due every year, and those support the operations of the association that maintains that privilege of self-regulation. There are also mandatory insurance requirements, which are tied to certificates of practice. So when you're offering services to the public, and those insurance requirements are there to protect, again, clients, public, that there's a basic minimum level of protection against errors and omissions. So that the Act really is designed around public protection, not around mitigating business risk. That's another decision you'll have to make on your own. Next, there's the continuing education requirements, which you're, again, as I said, you're all participating in. I think everybody probably knows or hopefully knows that this is an end of term is fast approaching. We're just about to come up on the 2-year term. And the reason that we have these requirements is because there's an expectation that it's not sufficient for architects to simply maintain the knowledge that they had when they were first licensed. Every member has to continuously improve and enhance their skills to remain competent. And obviously this is so true in this day and age when technology is expanding so rapidly. Nobody can be expected to kind of freeze their competence upon entry. We see also standards and ethics of professional conduct are challenged by the public having greater transparency, being more demanding of greater transparency from professions and professional complaints. There's been a number of laws and regulatory changes. I know there's big changes coming up in this industry as well. Also, workplace practices are constantly being revisited, analyzed, and updated as the industry advances. Without continuing education requirements, members risk falling into complacency, and they're at greater risk of making errors. Continuing professional development is really designed to address these issues. It is the self-governing profession's responsibility to establish programs of continuing professional development to ensure its members maintain that very high level of technical competence and professional conduct. I'm going to discuss a little bit more about competence and professional standards. So ethical and professional standards are in practice intertwined, and it's often really difficult to distinguish the point that one ends and the other begins. However, in general, ethical standards concern more with moral conduct, like honesty, integrity, candor, whereas professional standards are concerned with the ability, questions of competence, standards of business practices. Professional standards of practice are those that a reasonable professional peer would be expected to follow in the proper execution of one's professional duties. We're going to get into some examples of professional conduct a little further on. And now I just wanted to move to complaints and discipline. Okay, so the complaints and discipline mechanisms of the OAA, the reason that we have a complaints mechanism and why all regulating professions have to have this mechanism is to be accountable to the public. There has to be a means for the public to complain and for the regulator to respond to those complaints. As a self-governing profession, the OAA is empowered by legislation to exercise powers of enforcement over its members in the form of this complaints and discipline process. Obviously, it is in the public interest and the client that only competent and ethical practitioners are allowed to practice. And again, as I've said earlier, it's in the interest of the members of the profession and the profession itself. How well a profession exercises the power of discipline is a very sound test of the effectiveness of a self-governing body, and really has a direct effect on its reputation. So when we see a complaints process go off the rails and complaints committees making decisions that really favor the member, that's when we're most at risk. That's when we see governments intervening. So in terms of how that works at the OAA, there's a fairly standard two-tiered enforcement system, and there are two separate bodies. One is the committee that investigates and considers the complaint, and then the second is the committee that considers the prosecution of a conduct matter. When we receive a formal written complaint, it is referred to that investigating committee called the Complaints Committee to determine whether there is sufficient evidence of professional misconduct. So the Complaints Committee, at the Complaints Committee stage, they have three options at their disposal. They can either dismiss the complaint, they can direct that the matter be referred to the disciplinary committee for a hearing, and the third option is that the Complaints Committee can take such action as it considers appropriate. That can look like a written caution or requirements to complete additional education. But essentially, when we think about the right touch, when we kind of go back to that lens, that really comes through in the complaints process specifically, because we look again at the risk of the behavior or the alleged behavior. And that committee has the opportunity to consider how they can best motivate a behavioral change. And usually, we say that we reserve the discipline committee for the most serious risks to the public. We don't want to kind of take down the hammer unless it's absolutely necessary. So I will say, and it's pretty common, that about 90% of the matters that come through the discipline are resolved without a referral to the discipline committee. They're dealt with at the complaints committee stage. Okay.
I put a link to information about the complaints process while you were talking, Claire.
Thanks, Melissa.
So, all right. So we've reviewed all the principles of self-regulation. For some, it might be just a refresher, and also the associated benefits and responsibilities. So we come to the age-old question, so what? So while it's certainly important to understand the underlying roles and responsibilities, it's equally important to understand how they come into play in everyday practice. This understanding will really help all of us to better serve our clients and to ensure that the public is served and protected. So with the help of OA practice advisors, we have prepared 2 scenarios that will explore common pitfalls. Note that these scenarios are not legal advice. The OA, as Felix had mentioned earlier in the presentation, the OA doesn't provide legal, insurance, or accounting advice. If you need advice, you have to consult your own lawyer, accounting, insurance representative. We will focus on professional obligations as they pertain to the Architects Act and regulations. And there will also be suggested resources as part of the deck that you will receive, and again, encourage everybody to review them and refresh. So let's start. Poll number 5. Have you been asked to take over a project from another practice? Never. Only once in my career. Every couple of years. At least once a year in either case.
Thank you very much, Melissa, for poll question number 5. And the majority has already answered, so let's finish the poll and share the results.
All right, so about 40, almost half of you have never taken a project from another, taken over, sorry, a project from another practice. About a quarter has only once in their career, and the rest, again, seems very unlikely at this point. Next question. So, have you been replaced on a project by another practice? Never. I don't know, Felix, can you launch poll number 6, if possible? Okay, we might. Felix, you're muted. Oh, thank you. Okay, I just see it.
No, Melissa, I apologize for the delay.
Okay, no worries. Very similar to the other questions. I just want to gauge from our audience today, have you been replaced? Has your practice been replaced on the project by another practice? So the kind of the opposite. Never, only once in my career, every couple of years, at least once a year in either case. And I'm assuming right now everybody kind of knows where we're going with our scenario, so that should give you a bit of a sense.
Perfect, Melissa. Thanks again. And here are the results.
Okay, so I would say 75% of people that answered said that that has never happened to them. They've never been replaced on a project. Awesome. So I'll say at the OA hotline, this first scenario is probably the most frequent situation that we typically that's typically answered by a practice advisor. So we get calls from OA license members that got fired. We get calls from others that have been approached to replace another, sometimes by clients and even sometimes by municipalities. Also, as you can imagine, particularly because many of you have not experienced this in either case, the further the project is along, the more complex it is for everyone involved, including the consultants, to kind of pivot in those situations. So again, for the purpose of the scenarios, we won't be getting into the level of detail we would if any one of you called the practice hotline. So this is really kind of giving you a sense of testing out a little bit the content and the points that Claire and ourselves made earlier in the presentation. So here's a scenario. So I was retained by a new client to work on an interior fit up for a 50-seat restaurant at the base of a condo building downtown. Note that I was retained for the entirety of the project. So this is a project type that I'm really familiar with. I've done restaurants, at least 10 of them in the last 10 years. This is, however, the client's first. So I have to spend a bit more time than I had anticipated, and they're asking for a lot of changes on the construction drawing sets, some related to their own requirements, other related to supply chain issues with certain restaurant equipment. During the contract negotiation, I worked with the client to set clear expectations with them as it pertains to the number of meetings and drawing revisions in each phase. I can sense they're getting increasingly impatient with me, particularly when I submit extra service requests based on the time I'm spending on this project. I had just submitted the sealed permit set when I get a call. So the client communicated with me their intention to change practice and to terminate my contract once the permit is obtained. They admit that they have found another architect, actually a friend of the contractor, that they say is likely cheaper and has the ability to complete the project. I'm obviously extremely disappointed, and I asked if I can have a conversation to gain more context. The client refuses. In accordance with the standard contract, I request they convey the termination formally in writing. So this is we're going to launch a poll. So I'll go through basically what should I do next? What would you do next? So I would like to invite everybody that's to select all the situations that apply. So I would, or should I, review my contract as it pertains to termination clauses, payment, copyright, etc. Consult my lawyer if needed, and review regulatory notices number 3 and 5. B, expect a letter from Practice B in compliance with Regulatory Notice 3 and the Act. Seek indemnification, expressing that it may be unreasonable to hold me liable for misinterpretation of my documents. D, contact the municipality to advise I will no longer be doing general review. E, ignore the client, not return the calls. And again, you can select all that you think would apply if you had to give me advice, or what would you do in that context?
Thank you very much, Melissa, for the poll question for the first scenario. And let's give our members a little bit more time as there's
Yes,
a little
they're
bit of
fairly
text
long.
and-
Yes.
Perfect, but
I
it
think
looks
everybody gets to play a bit practice advisor today. Of what would you suggest, or what would you recommend to a colleague?
exactly. And Melissa, it looks like the majority has already answered. So let's finish the poll, and here are the results.
Well, I love the fact that nobody suggested to me to ignore the client. So I see Claire's like smiling and nodding of that's good. Funny enough, Claire and I kind of Claire, you found this scenario or the situation that
Yeah,
happened in the UK, right? So
yeah, it's out in the UK. There was an architect who had 5 separate clients who complained to the registration board that he just ghosted ghosted him and ghosted the clients rather, and eventually maybe one instance wouldn't have been sufficient to lose his license, but the board felt that it was serious enough for his license to be canceled. So everyone here is not going to run into that problem. I'm very happy to happy to see that. That's really, really good.
and again, just kind of overseeing. I know the statements are fairly long, but I encourage everybody, especially if like as if it does happen, to just refresh yourselves with some of the practice tips and regulatory notices. And if you have any doubts, like you can always call one of the practice advisors to kind of look at what might be helpful in that context. Uh, Also being very fluent and very aware of what's in your contract, maybe a standard OA contract, an RAIC, and sometimes even like making sure you also look at the supplementary conditions that may change and amend like the core agreement. Uh, Copyright is also a big one. If you, again, encouraging everybody to just kind of refresh when that stuff happens or if it happens. So I don't know if there was other little kind of bits and bobs in terms of, I don't know if you want to cover those points, Claire, if you want me to proceed.
Um, no, are we revealing the answers yet? Have we got to
Well, we
that?
did. So I think
Okay.
this was more kind of other kind of key points in terms
Yeah.
of issues
Yeah.
to.
Yeah, well, the other thing that a lot of people don't seem to know is around the part of the registered letter. So there's a section of the regulations that require when architect B, so in that case, it wasn't the person we were all supposed to pretend we were, it was the second architect. That architect has an obligation also. So if you're ever in that position where you are architect B and you're taking over a project, then you have to actually send a letter by registered mail. That's the wording of the act. It's a little bit antiquated now, but that's again the requirement to notify that you've taken over the project, and the client actually also has to notify you in writing as well. So just something to look out for if you find yourself in that situation.
And I would say, like, I'm going to repeat it with emphasis, contracts, 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 because the importance of having an agreement in place, like
Mhm.
it helps address unfortunate situations. It happens.
Yeah.
So, and it's those, that's not only there to protect your practice, but also the client. So again, um, there's link on the website. If you can't find the contract, just send us a note and we can kind of guide you through between a 600, which is the long form contract, the 800 or even the 900, because again, it's one thing to have a contract with your clients. You should also have a contractual agreement with all your consultants. So again, all of these will be shared as part of the deck. And there is some key sections you may need to, you may want to review in the regulations, as well as practice tip 1 that I forgot to mention as well. So we will move on. Poll number 7. How many of you have proceeded with work before getting written confirmation and agreement on fees and schedule? A, never. B, only once in my career. C, every couple of years. D, at least once a year in either case.
Thank you so much, Melissa, for poll question number 7. And it looks like, again, the majority has already given their answers. So let's end the poll and share the results.
Okay. So about 50% of attendees have admit that they've never proceeded with work before getting written confirmation or agreement on fees and schedule. And the rest, 15% only once in their career, 20% every couple of years, 19% at least once a year in either case. So this kind of will help us kind of bridge to our scenario number 2, when project scope changes. And again, especially with post-COVID reality and being like a lot of shortage of material and so forth, we have to do some either scope changes, design changes, and so forth. So this is just going to tie into that and some items to kind of bear in mind if it happens. So here's a scenario. I've been involved in a new residential development. The schedule is compressed and the design team is under pressure to meet the schedule. So we have a solid rapport with this client. They're relying on us to get the job done. So I'm like about to leave just to step out of the office when I get an email. So the client, they were able to acquire another site right next to the phase 2 of our current project. They want us to start the design immediately. So to keep the client happy, I tell the team, let's get on it and let's start doing a bit of initial planning, basically mobilizing staff onto some of the kind of these initial kind of setting the files and so forth to get moving. So here's a poll related to scenario number 2. What would you do next? A, keep the client happy and start the new scope. Deal with the details later. B, request written instruction to proceed before starting. C, prepare a contract change document, including a revised fee and schedule. D, tell the client we will need 2 weeks to hire new staff and avoid delaying the current work. So please select anything that you believe would be points to consider or recommend for me to do.
Great, Melissa. Thanks for the poll question for the second scenario. And the responses are still coming in. And it looks like now it has ended. Melissa, here are the results.
Okay, so I'll just switch my slide. So again, we would recommend kind of picking B, C, and D. I think again, we tend to want to keep our clients happy. I've admittedly done it in the past of just trying to kind of just get the ball going. But again, being able to have something in writing is always super important. Making sure it's documented in your contracts. And again, from the last one, number D is a bit of not a trick question, but ultimately you also have to look at staffing. That's again the reality of dealing with a brand new project that lands on your lap in such fashion. So on that note, yeah. So let's. Any points to kind of highlight, Claire, on this lovely scenario?
Definitely, and we were very intentional about choosing these topics because both Melissa in her capacity as overseeing the practice hotline and in my capacity in overseeing the complaints, these are the issues that do come up, or, you know, with specific details changed, obviously. And around communicating scope changes, that's something that gets a lot of architects into trouble. And I think, yeah, definitely My assumption is that it's from people pleasing or trying
Yeah.
to keep your client happy, which is very well intentioned, but is usually like, what's the expression? No good deed goes unpunished. And that is certainly the case when we see a big scope creep, I think is the word you would use. There are a couple I just wanted to highlight, and again, I haven't maybe highlighted clearly enough, but the rules relating to professional conduct are set out in section 42 of
Yes.
the regulation. So that's a really important place to find it. We don't have a nice separate code. It's sort of embedded, and there's a few others like the conflict of interest provisions are set out below, as are the the performance standards. But there are a couple of specific definitions of misconduct that relate to fees. So if you charge a fee that's for services not performed, that can be deemed misconduct. And if you undertake to provide architectural services at a fee that is not fully disclosed, fair, or reasonable, and again, that would be determined by the complaints committee about what is fair and reasonable. You could also get into trouble in a complaints capacity. So it's very important that you clearly set things out in writing. And again, we can't provide you with legal advice about how to do it, but the more information that you can provide, the better. And it's always just a question of risk reward. Like, what is the risk for not doing this? What is the reward? And I can tell you from my vantage point, it seems like the scales are very, very high on the risk and very, very low on the reward. So, be very intentional about those kinds of things in practice. And I think that kind of habit will serve you well in your profession.
Yeah, and this is a short list of information. I think you were mentioning, Claire, section 42 of the regs is actually highlighted there, and
yeah, good.
And there's also a great practice tip, number 15, on consulting contracts, managing changes and scope creep. So I recommend everybody to kind of maybe brush up on that. We also put practice advisory services with the launch of the OA 600, the OA contract suite 2021 last year and the year before, updated our OA standard extra services contract change form. That's a lot of words in one sentence, but again, really helpful. You can adapt it to the situation you're in terms of conveying the reason why you may be asking for extra services. And there's also really good information on managing that in the guide to the contracts that we have available on the website. Again, everything is free. And reminder also to shop Canadian Handbook of Practice that's put together by the RAIC is also a really great resource. It's now all online, and then chapter 3.9 is on architectural design services and fees, which again, great refresher, not only for yourself, but also for the rest of practice. So again, all these links will be available after when Felix shares the deck with everyone.
Yeah, so now we're,
questions, I guess. Should we do questions?
Yeah, why don't we go through a few of the takeaways? We have a couple of takeaways, and then I see there's a few questions too. Would you rather start with questions?
Yeah, let's start with the questions, and maybe just in case we don't want to repeat some of this stuff, and then we can conclude. And so question number one.
But let me just jump in. Just a quick reminder for all members: if you do have questions, please post them into the Q&A window at the bottom of your Zoom window. Our speakers are going to address these right now. Thank you.
Okay, thanks, Felix. Sorry, I stole your thunder. So question one, it seems that from the first diagram shown that the OA effectively is the office of the registrar.
Yeah, I can answer that. And I think if we go back, I don't know if we can go back to that slide, but it's the roadmap slide. And I think that in that context, the Office of the Registrar is the primary office that administers the Act. But when I also held up the other slide of the number of service areas within the OAA, all of that happens, with the with many other service areas. So, we've got continuing education, which is supporting ongoing competence. We have the communications department that's delivering all of the information. There's government relations that is working with ongoing developments in the legislative sphere. Obviously, practice advisory is doing a whole lot. So I would say that it's a team effort. It's certainly not all the Office of the Registrar. And then do you want me to speak to the second question as well?
Yeah, and I'll move back to
we didn't get too much into the nitty-gritty of title enforcement, so it's a good question. It's about the protection of the title architect, and I'm sure that the role of architect is I'm sure you're aware. Yes, we are aware that it's widely used in the IT business. Are we doing anything to protect in this area? So it's a really good question, very timely. The title architect is actually used in a whole bunch of industries. I think it's got this sort of cachet, this real cachet that people like. So we've seen it in like the fashion industry, the hair architect, all sorts of examples. And there have been other regulators that have specifically excluded enforcement on these titles when you're using them in conjunction with something like data architect, hair architect, because the way that the Act is worded is that when you're enforcing the title, it also has to be, there has to be a risk that it's misleading the public, that the person who's using that title could practice architecture. So generally speaking, and I say that in a big air quotes, generally speaking, we do not use a lot of OAA resources to enforce in that industry because, again, there's no threat to the public, and we have to allocate resources that are addressing threats to the public. So there are some situations where if they're just using the title architect, or if there's a job description that's using the architect and clearly not, we might ask them to change. But again, we wouldn't. The ultimate enforcement tool that we have is to bring an injunction. Injunctions are basically asking the court to say what the person's doing is illegal. That costs a lot of money, a lot of time, a lot of resources. And generally speaking, we are, again, adopting that right touch approach. So we use that very carefully. Okay, so, and the next question is related to service of architecture. Is this also a service protected under the Act? A lot of designers operating under a BCIN refer to their services as architecture rather than building design. Yeah, so that's a little more of a nuanced question. And again, if you look at the wording of the Act, and it's in section 46, the penalty related to using the title, if you're using any term that could be misleading to the public, then we do have the authority to enforce as well. And so generally speaking, if somebody is not a licensed architect and they're saying that they offer architectural services or architecture, or they practice architecture, we'd look at the whole matter, and then we would take action accordingly. So yeah, that one, again, because it's in the area of providing architectural services, it could be misleading to the public.
And just a reminder, everyone, if you have any questions, to put them in the Q&A area. And also, if there's specific situations, I might actually recommend that you just give us a call at the practice hotline if possible. Thanks.
Yeah, there's a question about scenario 1. If an architect is replaced with another firm and the client doesn't want to compensate, does the insurance cover the scenario? Our insurance that's required under the Act is for errors and omissions. So there's no remuneration, or like there's no compensation in that scheme. And that's not something that the OAA would address, really. And then there's a question about, do licensed architects not practicing but working in other fields have obligations around reporting misconduct? If you're licensed with the OAA, then you do have that obligation. So it's not just whether you're offering architectural services, you have that obligation. And there's a lot of questions about act enforcement. Who's in charge of the enforcement of the Architects Act? For example, if someone pretends to be a doctor or nurse or police and they put handcuffs and arrest the person, what would happen to the person, or if someone pretended to be an architect? So again, in the most serious cases, there is that there isn't a direct path to jail, so to speak. But we would have that ability to seek a court injunction. And we've only had one case in the last few years where the holding out was so serious and such a risk to the public that we were required to go to court, and the person wasn't. Generally speaking, most people are going to comply with the OAA's cease and desist letter. When they get it, they're going to say, okay, I wasn't aware that was a rule in Ontario, I'm sorry. They'll switch their website. And that's done. But if it's repeated and if it's ongoing and if there's a risk, then we can get that court order. Usually with the court order, there would come like a costs order. So there's the possibility that we could go as far as bringing a contempt order, but generally speaking, it's not going to go that far. So it's, like I said, probably one case every 5 years. We've just wrapped one up, and we're hoping it was quite a difficult case, and we're very much hoping that that we are not going to have to face that serious a situation again. I don't know if there are any that were jumping out at you. There's quite a few questions.
Yeah, I'm just kind of going through what might be the most, I would say, and I'm just going to mark them as done just because they seem to be. How could we access your slide after this course? This will be mailed, so I'm just going to take this out. This is answered. Bear with us. There's a question about OA contracts. It's 600 only contract between architect and client. The OA 600 is the long form contract for between yourselves and the client. There is also the 800, which is the short form. And there's also the 900 that you would have between yourselves and your consultants. So again, everything's on the website. We do have also a very handy index that kind of showcases all the available versions, also as the guides. And I recommend people to have both the contract and the guide, especially when you start kind of getting yourself familiar with it. That's a very helpful tool. And again, appreciating that some people have their own version, you can still kind of use the guide as some useful reminders to maybe perhaps have discussions with the lawyer that's helping you put your custom contract together.
I see a really good question here,
go
actually,
ahead.
that I want to address because it's a great question. It's if a licensed architect works in a firm but is not part of the certificate of practice, so I'm not quite sure what that means. So I think the indication is that the architect wouldn't sign or stamp or seal drawings. What would be the level of responsibility of the licensed architect not signing documents? So once you become a licensed architect, whether or not you're offering services under a certificate of practice, you are subject to all of the ethical and professional responsibilities that come with being a part of a regulated profession. So that means abiding by all of the requirements under Section 42 of the regulation. A lot of those have to do with sealing and signing, but again, you are a professional. You have to do continuing education. You have to pay your dues. So, and that can sometimes be frustrating because before you're licensed, you're still able to offer design services. And we didn't talk too much about the BCIN, but if you're not licensed and you're offering design services in the public domain, you wouldn't be subject to the regulatory requirements that are set out in the Architects Act and the regulation. But as soon as you are required. And it's also really important. Something else that comes up is once you're licensed, you are not permitted to offer any architectural services, even those services within the public domain. So a lot of times people ask, can I just design my own house? If you're not working under a certificate of practice, or if you don't have a certificate of practice to offer services to the public, you cannot offer any services. There are a few jurisdictions who make the exception for your own home, but the OAA is not one of those jurisdictions. So do be very careful once you're licensed. And if you're not offering services under a certificate of practice, just know that.
Yeah, some of the questions I would probably need a little bit more context to be able to.
Yeah, there's a lot around like what can we report? And I'm not sure if we had posted the ACT enforcement, the link to the ACT enforcement. Okay,
yeah,
good.
I did.
Yeah, and I would always invite us to, there's an enforcement at OAA email. If you're not sure, you can send it to us. I think there was another question that I saw that dealt with like, why don't we follow up with people who report? So the reason we don't follow up in ACT enforcement matters with the person who reports the potential breach is that there's specific requirement in the Architects Act that requires all of the information that comes to our attention to be private, to remain confidential. So we're only permitted to disclose information in very prescribed situations that are set out in the Act. And so we will take action, and that's why we report out the stats in the aggregate, but we're not reporting the specifics of the each individual case. But yes, please, if they're using the title architect and they're not licensed and they're practicing in Ontario, that is definitely a breach. That is definitely something we will address and do address. Yeah, there's some questions about changing architects. I would really just recommend that people go to that practice tip and specific section of the regulation as well, that who's got the obligation to do what. They're asking about if a client's changing architects, do they have to provide a termination letter to the consultants as well? So we don't regulate the consultants. There might be obligation, and that's why it's really important. Like there could be obligations in your contract. So what we're just saying here is, from a regulatory point of view, it might not be an issue, but it might be a legal issue.
From a practice, yeah, exactly.
Yeah,
From a practice side, you would want to consult with your lawyers, look at what the termination clauses are between yourself and the client. And if you have sub-consulted the consultants, then check what's in the termination for that specific. And again, the OA6, like the OA contract suite, kind of is all designed to work together. So if you have a 600 with your client and a 900, like all of that kind of is designed as a flow through. Anyways, if specific like kind of use of the contract, just give us a call or consult with your lawyer. That might end up for your specific situation. So I'm just also mindful if there's anything else. Otherwise, I know we're coming very close to time.
Yeah. Interior architect, yes, please report that as well. That's not permitted under the Act. That's something we've seen before. Someone's saying, so basically having a license, an OAA license just to carry the title. Yeah, as people make decisions, they might want to hold a license and then work either for a certificate of practice or an institution that carries their own insurance. So if you're still able to provide architectural services for a single employer, like if you worked for a university or the government. I think, Melissa, you worked in that capacity.
Yeah, I did.
So yeah, you're not holding a certificate of practice. You're just working for that one. Essentially, the client is the government. Or when I worked at the Law Society, we had hired an architect as well to just provide services to the Law Society. So those are situations where you might just want to be licensed without seeking the certificate of practice. Also academia, some people choose to be licensed. And it's important to remember too, if you do want to have a certificate of practice, rather, you need to maintain currency. So if you haven't been practicing architecture in any capacity, and then you want to become licensed and offer. So sometimes people maintain a license for those reasons as well. There's a whole bunch of reasons.
So do we want to move to our takeaways?
Yeah.
And kind of...
Great questions, though. Yeah, a lot of the questions I will say are kind of on legal advice, so that's why I'm sorry if we didn't answer them. I was like, we can't really answer that, but they're really great questions.
Yeah, and
So
some of them, I
encourage
everybody to for some of the ones that were related to practice and changing between architect A and B, as we often, just you can call 416-449-6898, extension 400, and one of the practice advisors will be available to have a chat and maybe guide you towards some resources that might be helpful.
Yeah, so I think my key takeaways are, when we talk about the regulatory landscape and the standards of practice, the ethical standards, we're not talking about gold standards. We're talking about the basic minimum standards so that you're not offside with the regulator. You're not going to get into trouble. Obviously, I think everybody here on this call is going to want to excel and exceed expectations in any way that they can. Part of that is just knowing what the rules and regulations are. So I really applaud everybody for listening if you're still on the call, and hopefully you've learned something or things have really piqued your curiosity. So I think that's really great. The other big tip, and this is actually very similar for lawyers. I'm a lawyer, so that's my profession. Very similar issues. Because we have more lawyers, there's a lot of statistics on what gets lawyers into trouble. And I would say it's from seeing the complaints, very similar for architects. It's when you don't communicate effectively. That's when you get into trouble. And on the flip side of that, I remember hearing somewhere that people will remember, they don't necessarily remember exactly what you say, but they do remember how you've made them feel. So if you're very dismissive or very impatient or don't really follow up or aren't really kind of taking the time to develop what we sometimes call soft skills, that can also create frustration with the client. I know there's a Prodemnity, I'm going to put up the link to a Prodemnity article about 6 ways to reduce risk. And that really speaks to communication. So you might feel like that's not important. And if you do, I would really encourage you to consider the importance of not just what you say, but how you say it when you're communicating with your clients.
And kind of building on that, it's important to sometimes kind of step back and assess the potential risks. That's also part of a healthy, proactive risk management strategy. And I know it's very easy to say, especially when you have like multiple conflicting priorities, projects, staffing, and so forth. But a hasty decision can have devastating effects. So especially at critical junctures in professional relationships, a misread email can lead to sending the wrong message. And again, that's just building on what Claire just said. So Same thing with a rushed drawing review can also create problems down the line. Complaints can be avoided, and ultimately it's a balancing act if you have multiple staff and even consultants and client groups. Communication, again, is key. Picking up the phone instead of writing an email when things get heated may take more time, but ultimately is more effective and can lead to greater communication and understanding between not only between yourself and the client, but yourself and your consultants, municipal building officials, and so forth. Also building on the development of soft skills, it's important to involve interns and newer employees and staff on that side of your practice, empowering your team with the resources we're covering today, engaging in discussions about the importance of understanding what constitutes professional misconduct is also really important. It's a means of opening lines of communication so that everybody can succeed. So on that note, I see Felix popped back up. Again, all of the key kind of links and resources, and I encourage you to really click through the act and the regulations, as well as what we can offer at the practice advisory services team level, and all the awesome resources we have on the website. You muted, Felix.
Thank you very much. Perfect.
Yeah, no worries.
Thank you all very much for a great webinar today. And
Thank
as we
you.
conclude this webinar, I would like to draw your attention to several important announcements. Our next webinar is scheduled for next week, February the 1st at 11 a.m. under the title, Reframing the Project, Project Management and Operational Management in the Design Endeavor. We also invite you to join us for this insightful session. The OAA will report your participation in this webinar to your transcript. Therefore, there is no need for individual reporting on your part. We kindly ask for your patience as we process and confirm the accreditation of the hours within the next few weeks. Additionally, all attendees will soon receive the presentation file via email along with a link to provide your feedback. Once again, thank you very much for your attendance and have a productive and pleasant remainder of your day. Thank you. Bye-bye.